stream, we are covering the U.S. Supreme Court, which issued 2 decisions today. None of them are major, none of them are sweeping, none of them will probably impact you in any significant way, but hey, it's the U.S. Supreme Court. And we love ourselves some U.S. Supreme Court over here on Uncivil Law. It's one of the things we do with our time. So we're going to read the U.S. Supreme Court decisions and explain them because that sounds like fun. And if explaining U.S. Supreme Court decisions doesn't sound like fun to you, I don't know what channel you're watching because Supreme Court opinions are the best. We turn our attention, first of all, to the case of EMD Sales versus Carrera, decided by the U.S. Supreme Court today out of the Fourth Circuit Court of Appeals. The facts of the case are thus. In 1938, the Congress of the United States enacted a Fair Labor Standard Act that guaranteed a minimum wage for covered workers and required overtime pay for those workers who worked more than 40 hours per week. But Congress exempted many types of employment from the requirement, including outside salesmen who primarily work away from their employer's place of business. The law places the burden on the employer to show that the exemption applies. Okay, so once upon a time, there was no minimum wage. And then the Congress of the United States said, hey, we have the power to regulate commerce. Of course we do. Everything is commerce, don't you know? And they said, we're going to have a federal minimum wage. Fantastic. And we're going to have a guaranteed pay raise. Fantastic. That's one of the things we want to do with our time. Cool. But we're also going to say that that law doesn't apply to all kinds of workers in all kinds of contexts. For example, certain positions can be salaried. If you're on salary, you don't get overtime because you're on salary, right? For example. So you can be like on salary or you can be hourly. And then if you work more hours, they give you overtime. And if you're salary, they don't give you overtime. Does your employer have the right to make any position salary? No, they don't. There are rules for that too, because Congress thought that far ahead, right? So they can't just arbitrarily make anyone salary. They can't just arbitrarily make people salary. But Congress said these positions are salary, these positions are hourly, these people get overtime, these people don't. Great. And it's on the employer to make the determination, and they're the one that have to prove the category. They're the ones that have to show what category the person is in. It's on the employer to prove it, that they're in the right category. Fantastic. We understand all those things. It's not that hard. The petitioner, EMD, distributes food products in the Washington, D.C. area. How nice for them. They're a food distributor. And employs sales representatives who manage inventory and take orders at grocery stores. Aha, we see what we've got. EMD distributes food. That's one of the things they do. They got some salesmen, but the salesmen don't work at EMD in their physical location. They work at the grocery store. That is their place of employment. That is where they work. They work at the grocery store selling things. Aha, we've got salesmen working at their place. Working at the end location. That sounds like maybe they're exempt, right? We just read that language. So maybe they don't get overtime. Cool, we understand this concept. Several sales representatives sued EMD, alleging the company violated the relevant law by failing to pay them overtime. So the company said, aha, you don't get overtime because of the law we just mentioned just now. And the employers are like, you're reading the law wrong. Which, it's just a dispute, or like anything else. You're reading the law wrong. We get some overtime, yo. I mean, we understand this. This isn't that hard. EMD argued that sales representatives were outside salesmen and therefore exempt from the requirement, right? They don't work at EMD. They don't work at our place of business. They work at the grocery store. So they're outside within the meaning of the rule. So they don't get overtime. Cool. After a bench trial, the district court found that EMD was liable for overtime because EMD did not prove, and here's the language that the Supreme Court is discussing today, by clear and convincing evidence that its sales representatives were outside salesmen. Aha. So that is the standard of proof. Well, what is clear and convincing evidence? It's something on the order of 70%, give or take. If preponderance of the evidence is 51% and proof beyond a reasonable doubt is something like 95 to 99%, what is clear and convincing evidence? something like 2/3 to 3/4, something like 66 to 75%, something like 70%, give or take. So EMD says these people are not entitled to overtime. And the court says, prove it. And EMD says, no problem, here's our proof. And the court says, you didn't provide enough proof. You didn't provide enough proof. You didn't meet the 70% threshold. So you lose. You lose. You didn't meet the standard. Okay? Fine. On appeal, the EMD argues the district court should have used the less stringent preponderance of the evidence standard. 51% would have been fine, Your Honor. I don't know why they're trying to make us prove it to 70%. All we need to do is show more likely than not, like, a normal civil case. That would have been fine. The district court's all over here like, how about 70%? But we're like 51% should have been fine. So that's all we should have been held to hold. And we were held to more. That wasn't fair. So the Fourth Circuit disagreed and affirmed the district court's judgment. So the Fourth Circuit says, nah, 70% is our bag. We like the 70% rule. 70% is the burden of proof. The Supreme Court's like, lol, no, it's not. The preponderance of the evidence standard applies when the employer seeks to demonstrate that the employee is exempt. 51% will be fine, says the Supreme Court. 51% will be fine. It's what we normally use in civil law. We use it all the time in all kinds of civil disputes. This is a civil dispute. 51% will be fine. More likely than not, will be fine. So it's on the employer to prove it, but you only need to get to 51%. So none of this 70% garbage. Yeah, that makes sense. Now we're going to go through the rationale. When Congress enacted the Fair Labor Standard Act in 1938, the preponderance of the evidence standard was default and remains so today. It sure does. It sure is. Preponderance of the evidence is typically what we use in most of the time. It is dominant then, it's dominant now. Correct. In civil litigation, this court has deviated from this default standard in three main circumstances. So as I said, not necessarily all the time. There are some exceptions. What are those exceptions? First, if the statute requires more, then more will be fine. So exception number one says, the law itself says you need to prove more. Cool, Congress gets to pass laws. They say they're the one that gets to set the burden. If they passed a law that says more is required, then more is required. Cool, we can live with that. We understand that. Number two, sometimes the Constitution can mandate a higher standard of proof. See, for example, New York Times versus Sullivan, dealing with defamation, for example. So sometimes we've said when it's rooted in a constitutional interest, for example, the First Amendment, then we'll require more. Because, if we took away your First Amendment rights on preponderance, that might not be fair, right? You have a right to speak. And so they have to prove more to take away your First Amendment right. I mean, that makes sense. We're trying to protect the First Amendment. So we're going to require you to show more things before we tell you to shut the hell up because you're lying about people. It's like, okay, that makes sense. That's fine. Third, in certain rare situations involving coercive governmental action, such as taking away a person's citizenship, a heightened standard might apply. Also, incidentally, taking away someone's kids is a classic, clear and convincing evidence standard. So we want to take away your kids. You're an abusive parent. You don't get to have your kids anymore. We think you're being abusive. It's like, well, taking away someone's kids is kind of a big deal. That's sort of what we thought, taking away someone's kids, it's kind of a big deal. So maybe, for the taking away someone's kids, we should require clear and convincing because, it's kind of a big deal. Right. Okay, that makes sense. Also, taking away someone's citizenship. Incidentally, by the way, you can't take away someone's citizenship if they're natural born. There's constitutional law on that case, on that point. So you cannot strip someone of their citizenship if they're natural born. They can strip themselves, incidentally, by forfeiting their citizenship, but you can't force it. You can't force them to do it. So we're talking about naturalized citizens and taking away their citizenship, which is possible, but still kind of a big deal. So we're going to need you to prove it by clear and convincing evidence. Cool. We understand that. But in most civil cases, including employment discrimination under Title VII, for example, discrimination on the basis of sex or race, for example, in an employment context, the court has consistently applied preponderance. So normally in civil law, even if it is like the employer is discriminating against me because I'm black, the employer is discriminating against me because I'm a woman, 51% will be fine. 51% will be fine. So even in the civil rights arena, 51% will be fine. The FLSA does not specify a standard of proof. And when the statute is silent, courts typically apply preponderance, right? Because it's the background rule, right? In the absence of a rule to the contrary, we're going to apply the standard rule because it's the standard rule, right? There is no language that says we want you to change the standard rule. Everyone knows what the standard rule is. Everyone knows preponderance is the rule. And so like if you didn't tell us otherwise, you probably want the default rule because you didn't bother to change it. Cool, that makes sense. This case does not involve a constitutional right that would require a heightened standard, nor does it involve the government taking unusual or coercive action. Look, you're not entitled to a minimum wage by Constitution. The Congress had to pass a law that says you're entitled to a minimum wage. The Constitution does not grant you a minimum wage. This is not the Constitution. This is a statute. And it isn't the government trying to take away your citizenship. It isn't them trying to take away your kids. It's, do you get overtime pay or not? Which is not quite in the same category of importance. I mean, we all like to get paid, but I think we can all agree not quite on the same scale. So preponderance of the evidence will be fine. FLSA cases are similar to Title VII employment discrimination cases where the court has applied preponderance. So is the employer discriminating on the basis of race? Are they discriminating on the basis of sex? Preponderance of the evidence will be fine. So FLSA preponderance of the evidence will also be fine. It's fine. The employees' policy-laden arguments for a heightened standard are unconvincing. Their argument that the FLSA protects the public interest in a fair economy does not necessitate the higher standard. Why would it? Right? I mean, probably that's what Congress was trying to do. They passed the minimum wage because they thought, everyone should be paid at least that much if they're working. It's like, well, yeah, that's what Congress thought, but, it's just a law like any other law, and it's just a civil law at that, right? It's just a please pay your workers enough money. You didn't pay them enough money. Please give them money that they're entitled to. It's just a civil law, guys. So preponderance will be fine. Other workplace protections, like those under Title VII, also serve important public interests. We would really prefer the employer not discriminate on the basis of race. That would be great. But they're still subject to preponderance. 51% will be fine. The employees argue that their rights under FLSA are non-waivable. So you can't contract it away, which is one of the whole things that they were trying to do in the first place by a minimum wage, right? It used to be before they passed a law that you could agree to work for anything you wanted. It was just simply a bargain for exchange. And as long as you agreed to it, then, fine, you do you. Congress came in and said, that doesn't work for us anymore. We're using our interstate regulatory authority under the Commerce Clause because, everything is commerce, don't you know? And we're going to say the minimum wage is this new magic number. And also you can't agree out of it. You can't contract out of it because that was the whole point, right? The whole point was that we don't allow you to have these agreements. So of course you can't contract out of it. That would be really, really dumb. So you are entitled to this no matter what you signed. Incidentally, by the way, this would also be true if you said that you were salaried, but you're not really because under operative law, which sometimes employers will try to do that. For example, they'll try to say, aha, these people are really salaried. They're management, don't you know? And it doesn't really matter what you sign at that point. It doesn't really matter what you sign because whether you're management or not is a fact-based question and not dependent on the agreement. For example, so you can't contract out of this. It doesn't matter what you signed. You're entitled to it as a matter of law. Incidentally, by the way, that's true for contracts generally speaking, because what contracts are allowed to exist is a matter of law, typically state law, because contracts typically are governed by state law. But as I just mentioned just now, the Congress of the United States passed the minimum wage law because of interstate commerce authority, don't you know? So, Normally, it's up to states to determine what you can contract for and not. In this particular situation, it's up to the Congress to determine what you can contract for or not. They've determined that these kinds of contracts are void as a matter of law. So they're void as a matter of law because that's what the law says, and that's the end of that discussion. That's easy. The employees argue their rights are non-waivable. Sure, you can't agree out of it, and therefore different from other rights subject to preponderance. Why would it be? That doesn't make any sense. But waivability of a right does not determine standard of proof. Right. I mean, it's yours whether you want it or not. How much proof do you need is not dictated by whether it's waivable or not. That doesn't make any sense. Whether the employees would fail to qualify as outside salesmen, even under preponderance, is left to the Court of Appeals. So we're not determining the question because the court just applied the wrong standard. Right? The court said you need 70%. I'm like, no, you don't. 51% will be fine. So like, do you have 51% or not? It's like, we're not going to figure that out. Let the courts below figure it out. So go back and, figure out whether or not they got their 51% or not. We're not going to do that. So easy enough. Go back to the Court of Appeals and figure out whether or not you got 51% or not. Kavanaugh delivers an opinion for a unanimous Supreme Court. Gorsuch concurs. Thomas concurs 9-0. Easy peasy, no problem. Easy peasy, no problem. Great. We turn our attention next to the second decision from the U.S. Supreme Court today. In this case, dealing with a Civ Pro question, which is kind of geeky for the Civ Pro people. So if you're a Civ Pro nerd, this case is for you. This is for the Civ Pro people in the hat. Can I get a what from the chat? What? Raise your hands in the air if you're a Civ Pro person and you just don't care. Great. This is the case of rural Canin versus Wullschleger. Gotta love these names sometimes, man. Respondent Anastasia Wullschleger sues petitioner rural Canin in state court, alleging that rural Canin has engaged in deceptive marketing practices. That's pretty easy. We think that your ads are lies. Or otherwise, right? We think your ads are lies or your business communications are lies. Great. The complaint asserted claims based on both federal and state law. Okay. Royal Canin removed the case, which is what we call it when we transfer from state court to federal court, because we can't call it transferring because that would be way too easy. So instead of calling it transferring, we call it removing because we want to make things more complicated. So we removed it, by which we mean we transferred it, but we removed it. We removed the case to federal court because there was federal law in the lawsuit. It's like, aha. They're right? I filed in state court using both federal and state law. Can you do that? You sure can. State courts can hear federal claims, generally speaking, or at least under some circumstances they're allowed to. Sometimes not, but yeah, generally speaking, federal courts can hear federal claims. They can do that. But you know who else can hear federal claims? Federal courts can hear federal claims. So if you file in state court, then the relevant law gives a right from the defendant to take it to federal court, because it could have been filed in federal court in the first instance. For whatever reason, the plaintiff chose to file it in state court, which is their prerogative. It's up to them. They can choose whether to file it in state court or federal court. But if they filed in state court, the defendant has the right to take it to federal court. Incidentally, not the other way around. If they had filed it in federal court, you're just stuck there. But if they filed it in state court, you can take it to federal court. The defendant has the right. And we've seen that before. So no problem. We've got a complaint, which is a lawsuit. We've got some federal law in there. We understand that. We're taking the case to federal court under the law. No problem. We understand all these things. The removal was premised on the federal claim, which gave rise to federal question jurisdiction. So the basis for the federal claim here is not diversity of citizenship. We're not different people from different states. In this particular case, it's that we're federal question. There is a federal statute we're suing under. There's a federal law we're protected by. So we're suing on the basis of a federal law. That's a federal question, as opposed to a state law, which would be a state question, right? So it's like, okay, so our basis for the federal court can hear it is that there's a federal question, namely a federal statute in play. Okay. And also, the federal court can exercise supplemental jurisdiction over the intertwined state claims. Right. So as I mentioned before, like you can file those claims in the first place in state court. right? You can file your federal claims in state court, and the state court can hear both your federal and state claims for the sake of convenience. For the sake of convenience. So if you take it to federal court, then they can hear both the federal and state claims because it would be really, really convenient, right? And that way we don't have different courts coming out with different decisions. The federal court can hear these questions. Life moves on. Everyone's happy. We get one adjudication, no problem. But of course, the federal court can't just hear state claims for the hell of it. You can't just file your contract claim in federal court because you want to, right? If it's just your dispute of your typical state case, it's just your typical contract case, you can't file it in federal court because there's no federal question. But as long as there's federal stuff along for the ride, or I suppose as long as there's federal stuff, the state stuff can come along for the ride. It's like, that makes sense. As long as there's federal stuff, the state stuff can come along for the ride. It's like, okay, that makes sense. We understand that. But federal court is not where Wullschleger wanted the case to be resolved. So Wullschleger, for whatever reason, really doesn't want this heard in federal court. They really don't want this heard in federal court. They really don't want it. So they do a logical thing to do. They amend the complaint, deleting every mention of federal law and petition for remand. It's like, aha, well, we're masters of our complaint. I mean, that much is true. In a lawsuit, right? We're the ones that get to decide what we're suing over or not. We're masters of our complaint. And so we really, really don't want this in federal court. So the way I'm going to solve that problem is by dropping every federal cause of action. Right? You can't stop me. You can't stop me from dismissing my own case. Right? That's like, I'm the one choosing to dismiss my own case. You can't stop me from doing that. And so now all that's left is state claims. Well, wait a second. No, that doesn't make sense. The federal court can only hear claims if there's a federal case. And now there's no longer a federal case. So how can the federal court still hear the case, is what they're saying. Shouldn't this go back to state court? Shouldn't this go back to state court? And there was a divide of authority on this point, by the way, on the federal courts. Some federal courts said yes, and some federal courts said no. Some federal courts say, well, we're not going to let you take it back to state court because you're just trying to game the system, right? We're not going to let you, you're the one who chose to file the federal claims in the first place. You knew that this was possible, and we're not going to let you dismiss the federal claims, or we'll let you dismiss it, but we're not giving up the state claims. Screw you. We're not going to let you choose. Screw you. And some federal courts said, no, we can't do it because the law doesn't allow us to. So there was a divide of authority on the issue. The district court said, screw you. The district court said, screw you. You're the one who chose to file it with federal claims. You knew this was possible. They chose the option that they were entitled to. You tried to drop all federal claims. Screw you. I'm not giving up the state claims. You can't make me. Okay? The Eighth Circuit reversed. Yes, they can. Yes, they can make you. In the Eighth Circuit's view, Wullschleger's amendment eliminated any basis for federal question jurisdiction. And without a federal question, the court concluded there was no possibility of supplemental jurisdiction because that's normally how we bring in state claims. It's supplemental. It's a supplement. They come in for the ride. But how can you supplement something that no longer exists? That's a really good question. And without federal question, the court concluded there's no possibility of supplemental jurisdiction over the claim. Cool. All right. So can you do this? Yes, you can. When the plaintiff amends their complaint to delete the federal law claims that enabled removal, leaving only state law claims, the federal court loses supplemental jurisdiction over the state claims, and the case must be remanded. So, I mean, simple. Right? Simple. In the end, it's like the federal courts were able to hear the state claims because they came along for the ride, but now they're no longer anything for them to ride with. So you can't hear the claim. It's got to go back to state court. And you can't prevent them from dismissing their own cause of action. That's their choice. And incidentally, they won't be able to bring it up again because they chose to voluntarily dismiss it. So it's like, they can't game it by bringing it back. They can't do that. So, that's their choice. So, back to state court you go. Good luck. Under the relevant text of the statute that gives all this, the supplemental jurisdiction statute, a post-removal amendment after we took it to federal court change to a complaint that eliminated any basis for federal question jurisdiction, also divests, which is to say removes, the federal question of supplemental jurisdiction. You only had jurisdiction because there was a federal claim. Now there's no longer a federal claim, so you don't have jurisdiction now, do you? Subsection A states that in any civil action to which the district courts have original jurisdiction, which is to say you can file it in district court, the district court shall also have supplemental jurisdiction over all other claims that are so related that they come to form part of the same case. So all related claims can come along for the ride. So we only have to adjudicate this thing once. Cool, that makes sense. The statute thus conferring supplemental jurisdiction over state law claims sharing a sufficient factual relationship with the federal claims. And in Rockwell, this court held that where a plaintiff files a complaint in federal court and then voluntarily amends the complaint, courts usually look to the amended complaint to determine jurisdiction. So, you're a master of your complaint. If you amend the complaint, it's now the complaint. Right? If you amend the complaint, it's now the complaint. Assuming that you could amend the complaint, because you can't always amend the complaint just because you wanna. Usually you get one for free. After that, sometimes you have to ask. So you may not necessarily be able to amend your complaint just because you feel like it. But if you can amend your complaint, then that becomes the complaint now because it was amended. So obviously that's what we're now suing over because that's what we're suing over. I mean, that's not that hard, right? So under the operative law, where the plaintiff in an original case amends their complaint to withdraw federal claims, leaving only state claims behind, they divest the federal court of supplemental jurisdiction. And the result must be the same in a removed case, that is a case that's already been taken to federal court, because nothing in the statute's text distinguishes from cases removed to federal court and cases originally filed there. So if it was originally filed in federal court and then you deleted all the federal claims, well, off to state court you go. And just because it started life in state court doesn't change that analysis. It's like, well, it started its life in federal court, but you removed all the jurisdiction for the federal courts. So it's like, well, I can't hear it. It doesn't really matter if it started in state court in the first instance. It's like, well, we're ping-ponging a little bit, but back to state court. Easy enough. The exclusion from the relevant law of post-amendment state law claims is reflected in the text of the law. Subsection C provides that a district court may decline to exercise supplemental jurisdiction over state law claims in the grant for 3 specific situations. We don't really have to get into this right now. Supplemental jurisdiction is optional. The federal court doesn't have to do it. And there are certain circumstances in which they don't. For example, the state law claims are so dominant. They're so dominant and so overarching that the federal court exercising jurisdiction would basically be an affront to state level authority, would be an example. So you found some way to technically try to dress this up as a federal case. You found some excuse, right? This isn't really a federal case. You just tried and you found some statute. You're like, I'm going to pin that in. And the federal courts can be like, screw you. The federal courts can be like, screw you. We see that you're trying to game this. Screw you. I'm not hearing this case. Wait, what? Right. The federal courts can do that. They usually don't, but they can because they don't like being screwed around with. So that would be an example. There are other examples in the statute you can read for yourself, obviously. If the grant of authority included leftover state claims in the amended claim, they too would have appeared on the list, right? So there is a list of reasons to do it, and this isn't one of the reasons. Congress didn't say this is one of the reasons. Even more than claims addressed there, they are ill-suited to federal adjudication. That makes the claims no mention of such claims demonstrated does not extend to them. Right, so they can dismiss or they can refuse to hear the state claims if the state claims are so dominant, so controlling, that this should be heard in state court. Well, if there are no federal claims at all anymore, then obviously the state claims are all that's controlling, because there's no federal claims anymore. So if you shouldn't hear the case when the state claims are so dominating that the federal question is like it doesn't exist, if it actually doesn't exist, well, even more reason to decide not to hear the case, right? If we're not going to do it when it functionally doesn't exist, we're definitely not going to do it when it actually doesn't exist. That result accords with Congress's usual view of how amended pleadings can affect jurisdiction. On that view, apparent in federal statutes, an amendment can wipe out a jurisdictional slate clean, giving rise to new analysis with new conclusions. Well, no shit. If you amend the complaint, it might change jurisdiction. It also might change your causes of action. It also might change your parties. It also might literally change anything else about the complaint, because that's in the nature of the amendment. It might change literally everything about it. So yes, that's definitely true. A defective allegation of jurisdiction may be amended. So if one of the things that you can amend is if you didn't do a really good job on saying why there's jurisdiction, you can amend it to fix it, maybe. So a case can come within federal jurisdiction. Yeah, it's like you didn't really do a good basis, but we'll allow you to fix it so it does. That'd be fine. Even if the case stated by the initial pleading is not removable, defendant can remove the case after receiving an amended pleading, providing the basis. So, like, again, like, we're not going to allow you to play games, right? We're not going to allow you to play games. So, like, everything has been tried. Everything has been tried. So some attorney somewhere is like, okay, I'm aware that if I put in federal claims in my state level cause of action, they can take it to federal court. So what I'm going to do is I'm going to be super sneaky. I'm only going to file this with state level claims. Okay. So it can't be taken to federal court. And then later, bam, I'm going to amend it to amend in the federal claims. And the courts went, screw you, you're trying to play games. Screw you, you're trying to play games. We're not going to let you play games. So, like, play stupid games, win stupid prizes, I guess, or something like that, right? And just the same here, the relevant law contemplates when the amended complaint is filed, the jurisdictional basis for the suit is renewed anew. The reading of the relevant law also parallels a slew of other procedural rules linking jurisdiction to the amended rather than initial complaint, because why wouldn't it? The amended complaint is the amended. It's like the original doesn't exist. That's kind of the point. In deciding which substantive claims to bring against which defendants, a plaintiff can establish, or not, the basis for federal question jurisdiction, because the plaintiff is master of their own complaint. So the plaintiff can establish it or not establish it, because it's up to them. If the plaintiff amends their complaint, the new pleading supersedes the old one. No shit. And can bring in the suit either in the newly within or newly outside the federal court's jurisdiction. So if you added in federal claims, it's newly within the federal claims. Congratulations. If you remove the federal claims, it's newly without, which is to say outside the federal question. Congratulations. It's like you amended it, you amended in the jurisdiction, you amended out the jurisdiction. Well, either way, you made the choice. So either way, guess what you're getting now, right? You're getting exactly what you picked. The relevant rule hosted of variations in both original and removed cases. Adding federal claims can create original jurisdiction where once it was wanting. So, before, not so much on federal, but then you added in some federal claims. So, it's federal now. An amendment can either destroy or create jurisdiction in an original diversity case, right? Maybe I added in a party that destroyed a diversity, or maybe I amended it in so that I created diversity, or whatever I'm doing, but I still have the ability to do that. So, like, I can create jurisdiction, I can destroy jurisdiction with my lawsuit. It's amazing. It's amazing. It's unbelievable. It's so, yeah. Similarly, if removing a case was improper because the initial complaint did not contain a federal claim, the plaintiff's later assertion of such a claim would establish jurisdiction going forward. So someone's like, these state level claims, there's only state level claims. Someone's tried to remove those before, because of course everything's been tried. Everything's been tried. So there were only state level claims, and someone tried to take it to federal court, and the federal court's like, what are you doing here? What are you doing here? There are no federal claims. And then they kicked it back. And then the plaintiff amended in federal jurisdiction. And then they took it to federal court. It's like, well, okay, now it's there, so I'll take it. Yoink. Right? I mean, everything's been tried. You can't game this. I suppose you can game it in so much as you get rid of your claims, but then you're just not suing them. So the only way you can game this is by not suing them. We were suing you for federal claims, but now we're not. Well, then you're not suing them for the federal claims. So that's only a benefit to the defendant. So the only way you can game this is by not suing them. The only way to win is by not playing. Which, you know, if that's what you want to do, if you're that desperate to stay out of federal court, then you do you. Then you do you. You get to go to state court, but you lost your claims. So good luck with whatever's left, I guess. And by the same token, amending in jurisdiction to join a non-diverse party, in other words, now suddenly there's the same state on both sides of the V, right? It was Kentucky versus Ohio. And so it was diverse. And then I amended it. So it was Kentucky versus Ohio and Kentucky. Oh, now it's not diverse anymore. All right? Yeah, that would destroy jurisdiction. And the federal court must remand the case to state court. It removed and original cases alike. The rule that jurisdiction follows the operative pleading ensures the case, as it will actually be litigated, merits the federal forum. So the amended complaint is the thing that controls, and the controlling the thing should control. Wow. I mean, it's like magic, right? It makes you wonder why you need a U.S. Supreme Court case for these bold propositions. But sometimes, you know, man. Royal Canin contends that this court has twice before reached the opposite conclusion. So they're like, there's precedent against it. Okay. First in Carnegie Mellon, and next in Rockwell in a footnote. If you're citing footnotes for precedent, you're not necessarily off to a great time. But in each case, the relied on passage is extraneous to the court's holding and reasoning, and so cannot bear the weight of the argument. In other words, it was dicta. So twice before we said, yeah, you know, this will be fine, but it was dicta. So no. The footnote in Rockwell does state the rule that Royal Canin propounds. So the footnote did say the thing, but, you know, whatever. When a defendant removes a case to federal court based on presence of federal claim, it says an amendment eliminating the original basis for federal question generally does not defeat jurisdiction. So you have the magic footnote, but, you know, we don't care. But Rockwell was an original federal case not removed. So his drive-by assertion of a jurisdictional rule for removed cases was entirely outside the case being decided. That dictum cannot overcome the court's analysis or Rockwell's own core insight that federal courts look to the amended complaint to determine jurisdiction. Kagan delivers an opinion for unanimous Supreme Court. 9-0. So, yeah, that's the end of that. So both are fairly esoteric cases. Neither one is going to rock your world. Both are fairly niche. But, you know, the U.S. Supreme Court, not every case the U.S. Supreme Court decides is necessarily going to be a firebrand. Sometimes the U.S. Supreme Court is just dealing with some really esoteric, somewhat petty shit. And that's kind of what they did today. It was a little esoteric and a little bit petty, but, you know, hey, 2-9-0 decisions. So that's all there is to that. So fine. So I don't know if there's anything else to discuss. Trump did get a ceasefire. I saw that. Yeah, the Israel-Gaza war has come to an end. That is so funny. That is so funny to me. It is so hilarious. It's like we've had a substitute teacher for 4 years, and now everyone knows that the real teacher's coming in. Everyone's straightening up real fast. It's like, oh, there's suddenly a ceasefire in the Middle East. It's like, man, everyone's taking a long, hard look at their calendar. Everyone's taking a real hard look at their calendar. Oh, suddenly there's peace in the Middle East. Amazing. Yeah. It's just phase one. Phase 1 is better than phase 0. So, it's a start. Is there anything else to discuss right now? I don't see anything else. Is this the TikTok ban? No decision on the TikTok ban yet. If there was a TikTok ban decision, I would have put that in the title. Yeah, no decision yet on the TikTok issue. They've still got 2 days to issue something. So I don't know what they're going to do. My feeling is they're going to let the ban go forward. That's my thought. Is they're going to let the ban go forward. The Supreme Court should it might be a very short thing. New hat stand? What's wrong with my current hat stand? My current hat stand is very functional. It looks nice up there. Do I think Musk will buy TikTok? Nah. I don't think ByteDance is going to do it. I think that ByteDance is going to let it go dark. I think they're playing chicken, and I don't think they're ready to call it yet. Especially with Trump saying the things he's saying about letting TikTok go forward and all the rest of it. So I think that they're playing chicken, and they're expecting the U.S. to blink, and not irrationally. Maximum Bacon gives $10. That's very, very kind of you. Thank you. Yeah. So, you're complimenting the new hat stand? Oh, thank you. I appreciate it. Yeah. I think that they're going to play. I think they're just going to play chicken. And I think the Supreme Court's going to allow the ban to go forward. It'll be interesting to see if I'm right. It'll also be interesting to see because, normally this would be a merits decision. And normally in a merits decision, you're expecting a fully written opinion. But they'd have to write a fully written opinion pretty fast, which, they do have clerks and stuff. So they might have their clerks, burning the midnight oil, writing an opinion as we speak. But they might also, drop, an order with an opinion to follow, which the Supreme Court doesn't usually do that. So it'll be interesting to see how they do it. But my expectation is they're going to let the ban go forward. Yeah. Thank you, Bird, for the $10. Yeah. I think the ban is legal. I think the ban is legal. So they could grant a stay. That's true. If they can get 5 votes, they could put in an administrative stay if they have 5 votes to put in a stay. That's true. So they could delay the decision. They could delay the decision if there's 5 votes to delay it. But my bet is that they're going to let the ban go forward. So my bet is that they're going to issue a decision either tomorrow or probably Friday, probably at the end of business on Friday. Maybe they issue it on Saturday. I'm not sure what the last time the Supreme Court issued something on Saturday is, but, maybe those clerks are writing very, very fast right now. The free sandwich gave $10. Thank you very much. That's very kind of you. Erin Bally said a stay. She had a long analysis. It's not an unreasonable opinion to think that there's going to be a stay. It's not an unreasonable opinion to think that there's a stay. I mean, you need 5 votes for the stay. The Supreme Court is being asked to do a lot very fast. Now, the Supreme Court in its history has on occasion moved this fast. So it wouldn't be unprecedented, although it would be unusual. Usually the Supreme Court doesn't like to move that fast. But they've been known to ball when they really need to. Plus, of course, with Trump coming in, if you think that they're trying to give Trump the political win, if you think that they're trying to moot the issue by letting Trump do something on the executive side, if you think that they want to allow Trump to moot the issue, then a stay would be rational. And then they say the whole issue is mooted by whatever Trump did or something. But I don't think so. I think that they're gonna. My bet is that they're gonna let the ban go forward, but they could issue a stay to see what happens. It's possible. I suppose it really depends. I suppose it most depends on whether or not you think that the Supreme Court wants to allow Trump the opportunity to try to moot this so they don't have to decide the issue, or because they just want to do it because of political reasons. But or they don't want to feel like they're hamstringing the president or something. So if you think that, then that would be a pretty reasonable opinion. But I listened to those oral arguments. So did you. You listened to them with me. And yeah. This even if TikTok kidnapped the children of Jeff Bezos, the US government would be powerless to force the forced divestiture of the Washington Post. What the fuck are you talking about? Even if they kidnap Jeff Bezos, how'd Jeff Bezos' children wind up in this hypothetical? Yeah. I don't even think the First Amendment applies. I don't even think it's a First Amendment issue. Because it's whose First Amendment is it? ByteDance? Screw them. They don't get First Amendment protection. They're a bunch of foreigners. They're a bunch of foreign commies. They don't get First Amendment protection. They're a bunch of foreign commies. Were they pumping noxious gas in the Supreme Court chamber that day? I don't know, man. It was a very weird hypothetical from that guy, Neil Francisco, and he was Solicitor General for like 3 years. I'm like, you really think this is working, Neil? You think this example is working? I don't think it's working, man. You know? Yeah. All right. Well, I guess I'm going to go ahead and sign off. Maybe there's something else for me to cover today, but I don't have anything to cover right now. So I think I'm just going to stop the stream unless there's something more. This is going to deprive 170 million Americans of their ability to speak. No, it doesn't. I do like that, like, everyone's trying to, like, rush to this other Chinese app. It's like, what the fuck, man? It's like, what the hell? Wall sit? You want me to wall sit? See how long I can wall sit? Maybe later. You know, actually, what if I do it now? I'll do a wall sit for you on the basis of it will give me some exercise. Yeah, I'll do a wall sit for you. Oh Lord. All right, I'll do a wall sit for you. My legs. I'm not sure how long I can do it because I was doing some squats earlier. Oh yeah, no, we'll definitely do the Texas ban case tomorrow or something when the transcript is available. I forgot to mention it earlier, but yeah, we'll definitely be covering that. If not tomorrow, then probably Friday because I'm waiting for the transcript to drop. But I am definitely very interested in covering the prurient, salacious content ban from Texas. I'm definitely interested in covering that. All right, let's see. Do I have to move Tiger out of the way? I don't think I do. All right. So I just said, like, oh my god, this hurts. Okay, this actually really hurts. Oh wow, that hurts a lot more than I thought it was going to. Holy shit. I'm not sure I can do this for very long. Help. Man, that really hurts. It really hurt. All right. I'm going to sign off. We'll definitely do the Texas thing in the near future. I've been on civil law. Until later, my friends. I hope all's well. Cheers for later, my friends, and goodbye.